Ben, are we ready? Ben, are we ready?
Yes, ma'am. John, can we
Yeah, do you have the countdown
Jason, are we ready?
script?
It's right here.
Okay, he's telling witnesses right now that you're about to start. So, what's on your next?
We will start the hearing shortly and then wait 60 seconds before commencing the call to order. The period of time is needed for us to move forward, and we ask everyone to get prepared. Subcommittee will come to order. Without objection, the chair is authorized to declare recesses of the subcommittee at any time. We welcome everyone to this morning's hearing, A Fine Scheme, How Court-Imposed Fees and Fine Unjustly Burden Vulnerable Communities. Before we begin, I would like to remind members that we have established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of our hearing today. If you would like to submit materials, please send them to the email address that has been previously distributed to your officers, and we will circulate the materials to members and staff as quickly as we can. I would also like to ask all members to mute your microphones when you're not speaking. This will help prevent feedback, and other technical issues, you may unmute yourself anytime you seek recognition. We want to continue in the Crime Subcommittee to have as many important hearings as possible with the idea toward legislation and our major theme of criminal justice reform. So I'm certainly grateful to all of the members that are here and have been faithful in their attendance on both sides of the aisle, and of course to our chairman, who has been extremely engaged in our work. And the commitment of our ranking member as well is very important. So thank you for your presence here today, along with the witnesses who will give their testimony to help contribute to being problem-solving in criminal justice reform. Today, the subcommittee hears testimony on the impact of fees and fines have on families and communities. To be clear at the onset, the topic today does not cover restitution or other equitable relief for victims, but focuses costs imposed by the criminal justice agencies upon those who come into contact with the criminal justice system. Just as an aside, let me indicate that I'm very pleased that the Nadler-Jackson-Lee bill, Victims of Crime Act fix, was signed into law last week. That indicates our commitment to protecting victims all over the nation who have been impacted from crime to human trafficking. And we're glad to see that movement. Here we talk about a different aspect of fines and fees, and I believe it is important to find a solution to the oppression that comes about on individuals who are impoverished. These charges to show up at every level of the criminal justice system. There are fees for traffic detention, phone calls from jail and prison commissary, and fees for a pretrial release, such as electronic monitoring, supervision, and parole fees. Some of these fees can be hundreds of dollars a month, which in some places can be imposed before guilt is adjudicated. The United States Department of Justice investigation of Ferguson, Missouri, that followed the tragic and violent shooting of Michael Brown brought the imposition of fines and fees in the justice system to the forefront of our nation's public discourse. In its comprehensive report, the DOJ concluded that the Ferguson Police Department, the municipal court, and the city of all depended on fines and fees to operate. Fines are monetary penalties ordered by a court to be paid by the defendant after arrest that are not restitution or other equitable relief. Many experts argue, and I believe factually, that the fees charged by Ferguson, like those levied elsewhere in the United States, helped entrench poverty, exacerbate racial disparities, undermining public safety, diminishing trust in the judicial system, and as well, trapping people in cycles of poverty and punishment. After arrest, most judicial systems require to have people pay fines and fees. These fees are for minor traffic and municipal code violations, misdemeanors, and some low-lying felonies, and as well, and are considered resources, unfortunately, for funding the government. That is of great concern to all of us, and I would make the argument that as we proceed, we'll find out the basis of all this. To be clear at the onset, the topic today does not cover restitution, as I've already said. What the imposition of fines and fees have done is create a two-tier system of justice. Those that can afford to immediately pay their court debt can exit the justice debt system after the underlying matter is resolved. Americans without the means, by contrast, may be quickly trapped in what can be for many a spiral of mounting debt long after their case has been settled. The total scope of the court-imposed fees is astounding. By some estimates, criminal justice debt in this country will exceed $27 billion without reliable data. The exact amount is unknown and likely unknowable, but it still appears to be a staggering level. On a personal level, the harm caused by court-ordered debt can be grave. I remember going to the region that our member represents after the shooting of Michael Brown. Our vice chair comes from that area and has spoken often about it, Vice Chair Congresswoman Bush. I remember going to that area and meeting women who, head of household, who unfortunately were caught up in the fines and fees, lost their jobs, and were not able to take care of their family. Some finding found disturbingly that 83% of those surveyed gave up necessities like rent, food, medical bills, car payments, and child support in order to pay their court debt. Communities are harmed as well. The same study found that 38% of respondents admitted to having committed at least one crime to pay off their court debt. About 20% of those whose only previous offenses were traffic violations admitted to committing more serious offenses, included felonies, to pay off their traffic tickets. This means that levying fines and fees take food out of the mouth of those who can't afford to pay them and decreases public safety by perversely incentivizing further criminal behavior. The harm doesn't stop there. The deleterious impact of the imposition of fees and fines is most acutely felt by juveniles. Youth who have interactions with the juvenile justice system often are required to pay fines and fees. Juvenile fees, like adult fines and fees, include juvenile detention fees, fees for drug testing, and charges for physical and mental health treatment. The practice of passing fees imposed on juveniles to their parents or guardian is too common and has the effect of weighing down an entire family, and particularly an impoverished family. The woman that I met in the Ferguson community had been in jail because she was not able to pay the fines and fees. When juveniles fail to pay fines and fees, the debt may also follow them into adulthood, putting them a step behind their peers even before they've had a chance to begin their adult lives. Weighing down youth with debt at the start of their adult lives undermines the very goal of our juvenile justice system, rehabilitation. I applaud the efforts in the states to eliminate the imposition of fees and fines, but more must be done to remove these barriers to youth rehabilitation. That is why we're holding this hearing. More must be done. One of the most troubling trends in the collection of fees and fines is the outsourcing of rehabilitative services to entities that then charge fees for their services. This is a circle that one does not want to be in. These fees, which often become collectible by court order or contract, are sometimes levied without the supervision of a judge. This type of arraignment can elevate private supervision companies to the position of determining not only whether a supervised violate the terms of their supervision, but whether a fine should be imposed, and basically creating more debt. I'm gravely concerned that this type of arrangement is both corrosive to public trust in the criminal justice system and that it incentivizes private companies to violate supervisees simply to impose or improve their bottom line. That is absolutely ridiculous and, of course, tragic. What's particularly troubling is the report's finding that private companies charge many fees for profit. Evidence shows how levying court-imposed fees and fines is not only harmful for those who can't afford them, but it's a bad deal for the taxpayer. A 2019 report by the Brennan Center for Justice revealed that the counties studied, including those in my home state of Texas, spent more than 41 cents of every dollar collected from fees and fines on related in-court hearings and jail costs, meaning that for every dollar imposed, only 59% made it into state coffers. The harm these fees and fines cause does not outweigh the fraction of the charges that are ultimately collected. Our criminal justice resources should be used on other high-priority issues like preventing and responding to violent crime and reducing recidivism. As we discuss this pressing issue, I hope to work across party lines to serve our constituents and communities better. Already, state and local governments have recognized the terrible cycle of harm that justice-related fees and fines can impose and have begun enacting essential reforms. Groups across the political spectrum have expressed support for reducing and eliminating the use of fines and fees. That is why I believe this common ground is good for a discussion for this committee, where we will be working in a bipartisan manner to solve this problem and to help Americans overcome the detours in their life, but to do it under the light of justice. I look forward to working with my colleagues to address this issue. It is now my pleasure to recognize the ranking member of the subcommittee, the gentleman from Arizona, Mr. Biggs, for his opening statements.
Thank you, Madam Chair, and I apologize for my tardiness coming from our own conference meeting, so I apologize. Once again, the Subcommittee on Crime, Terrorism, and Homeland Security of the United States House of Representatives is holding a hearing on a topic that, quite frankly, is mainly a state and local issue. I was pleased at last week's markup where the chair expressed a willingness to work with us on a bipartisan basis on issues such as the flow of fentanyl across our southern border and the crisis that it is creating throughout the country. In February, news organizations announced with shock that more than 100,000 aliens had been encountered at the southern border. The White House and Secretary Mayorkas worked overtime to deny that there was a crisis at the southern border. This committee did its part by refusing to hold a hearing on the Biden border crisis as we had requested a hearing. In March, the Republican members of the subcommittee sent you a letter requesting that the chair schedule a hearing so that subcommittee members have the opportunity to hear from and question Biden administration officials about how the Biden administration's failure to secure the U.S. southern border has allowed transnational criminal organizations, smugglers, and drug traffickers to engage in criminal activity and harm public safety. We've yet to receive a response to that letter. Unfortunately, the number of encounters at the southern border has grown each month since President Biden took office, and last month more than 188,000 aliens were encountered by CBP at our southern border. I've taken multiple groups of members to the border over the past several months, visiting from San Diego, Calexico, Yuma, Tucson, all the way to McAllen, multiple times in most of those spots. In each of these areas, we heard and saw the same thing. The Biden administration's policies have created a crisis, and we renew our request to hold a hearing to hear directly from Biden administration officials so that they can be held accountable for the crisis they created. The surge of aliens at the border is allowing drugs and other illegal contraband to flow across the border because Border Patrol is occupied caring for aliens instead of securing the border. I hope that our next hearing will be on this topic. After all, this is the Subcommittee on Crime, Terrorism, and Homeland Security. This committee cannot continue to ignore the crisis at our southern border and the impact that the crisis is having throughout the nation. I also hope the chair will hold a hearing soon to examine the dangerous efforts to defund the police and the increase in violent crime in American cities. In June, all the Republican members of the subcommittee wrote a letter to the chair requesting a hearing on these issues, and we've yet to receive a response to that letter as well. Don't get me wrong, the issue of fines and fees, I think, is a very important issue. It's one that should be looked at the state level. The Eighth Amendment to the Constitution prohibits the federal government from imposing excessive fines, a prohibition that the Supreme Court incorporated against the states in a February 2019 decision. Studies have found that criminal justice debt is sharply rising across the country, that associated fees lead to a cycle of debt, and that this debt could impede reentry and rehabilitation. But this is largely a state issue. The federal government should not be in the business of bribing states to implement specific policies. Doing so discloses what Justice Brandeis called the laboratories of democracy. Why would we wish to do that? Let the states work these matters out on their own. In fact, many states are already taking a leading role to reform fines and fees in the criminal justice system. When I worked in the Arizona criminal justice system, both as a prosecutor and then later as a criminal defense attorney, I will tell you that nothing was more dismaying to me to see someone be fined, for instance, $100, and yet the surcharge, which is what we called all the add-ons, would be about 100%. So they would end up paying a $200 fine for what fine and fee for what should have been a $100 fine per statute. But my experience was routinely judges were allowed to waive those surcharges in Arizona. They didn't always do so, but we could advocate for that. But this year, the state of Arizona enacted one of the changes that will be advocated for at this hearing today. In April, a change was enacted in Arizona so that Arizonans will not have their driver's license suspended if they do not pay traffic fines or fees. This change is estimated to impact 30,000 people in the state. It is a pleasant change. I cannot tell you how many people used to come in to see me, both as a prosecutor and then later as in representational capacity, whose license had been suspended so they couldn't get to work in a very broad and large metropolitan area that had very little public transportation services. They would lose their license, thus losing their job, thus being in a cycle of problems. The state has now exercised its legislative prerogatives to change that. I hope it is a positive change in the state of Arizona. But the important and salient point here is that the state legislature made that change, that corrective, without being coerced or enticed by the United States Congress. Between February and April 2021, several other states, including Florida, Indiana, my own Arizona, New Mexico, and Oregon, considered legislation that would eliminate fines, fees, and court costs for juveniles in the criminal justice system. And just last month, Nevada enacted a law to end the practice of suspending an individual driver's license or prohibiting an individual from applying for a driver's license because of an unpaid fine or fee. Again, last month, Colorado enacted a law to eliminate certain monetary amounts a juvenile or juvenile's parent or legal guardian in the criminal justice system is required to pay, like fees for applying for court-appointed counsel. These discussions and decisions are taking place exactly where they should be taking place, in state houses across this great country. As I noted earlier, states are the laboratories of democracy and are better equipped to make decisions regarding the fines and fees implemented in their state statutes and municipal codes. In Federalist 45, James Madison wrote, quote, "The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. Yet here we find ourselves in this committee in hearing after hearing or markup after markup discussing matters that are more rightly state issues. My colleagues are looking to impose their wills on the states through grant programs, and I urge that practice to be discontinued. In 1905, there were 4 grant programs. Today, there are more than 1,300 grant programs. This is the problem I think we should be looking at. And with that, Madam Chair, I thank you for your time. Again, I apologize for being late. I look forward to this hearing today, and I yield back.
I thank the gentleman, and I thank the gentleman for his response in terms of the delay that he had. Thank him, extend him courtesies.
Your mic.
That he had an earlier meeting. It is now my pleasure to recognize the chairman of the Judiciary Committee, Mr. Nadler, for his opening statement.
Thank you, Madam Chairwoman. I thank the Chairwoman for convening this hearing on a topic that has not received the attention it deserves, given the impact it has had on communities across the country. And I would remind the ranking member that the Constitution now has the 14th Amendment, which it didn't have when the Federalist Papers were written, which changes things a little. Over the course of the last 3 decades, the increased imposition of fees and fines in the criminal justice system have had an increasingly deleterious impact on individuals, families, and their communities. In recent years, states and localities across the country have imposed a variety of fees and fines on everything from minor traffic violations and municipal code violations to misdemeanors and felonies in order to pay for programs traditionally funded by tax revenues. When you actually examine the numbers, it's not clear that these fees and fines are even generating any revenue. One study found that some counties spend more than 41 cents for every dollar collected in fees and fines. One New Mexico county spends as much as $1.17 for every dollar it raises through fines and fees, incurring a net overall loss. But this financial shell game does not measure the real cost to communities. Rather than improving public safety, frequently such fees and fines have only served to place an undue burden on low-income communities and communities of color. In fact, by many measures, fees and fines have had an adverse impact on public safety. In a comprehensive report in the city of Ferguson, Missouri, the Department of Justice found that the Ferguson Police Department, the municipal court, and the city all depended on burdensome fees and fines to operate, trapping its citizens in a cruel cycle of poverty and punishment. Ultimately, what the DOJ found in Ferguson is occurring in jurisdictions across the country. This dynamic is often exacerbated by the fact that courts rarely consider a defendant's ability to pay the fines that they impose. In many cases, those who cannot afford to pay fees and fines receive warrants for failing to comply. If they cannot pay the debts to satisfy their outstanding warrants, which may increase over time, making them even more unaffordable, these individuals may even be jailed. This is, in effect, a modern debtor's prison. A person's liberty is deprived because they cannot afford their court-imposed fine or fee. The practices like those in Ferguson and elsewhere diminish public trust in our criminal justice system and perpetuate the notion that equal justice under the law is only accessible to those who can afford it. At the other end of the criminal, and often these fees are imposed on the family of the person who couldn't afford to pay it, and they can't afford to pay it. At the other end of the criminal justice process, fees are often imposed on individuals after a conviction, creating yet another barrier to their reintroduction into safety. Everything we've been talking about till now is before anybody's convicted of anything. We have worked to ease the reintegration of those who are recently released from jail or prison. Burdening individuals who make the journey back to being full members of their communities with fees and fines stands in stark contrast to these efforts. Thankfully, change in this area is afoot. The cost imposed on individuals and families without discernible public safety benefit has led many jurisdictions to pause imposing and collecting fees and fines. Some other jurisdictions have eliminated fees and fines altogether. In a time of deep partisan divide, I hope that this is an issue that reaches across the political spectrum to build a bipartisan consensus on reform. I look forward to the testimony of our witnesses. I thank the chairwoman for convening this hearing, and I yield back the balance of my time.
I thank the chairman very much. We will recognize the ranking member of the full committee if the gentleman from Ohio arrives, and we will now move forward to the swearing in of our witnesses. We welcome all of our distinguished witnesses, and we thank them for their participation. I will begin by swearing in our witnesses. I ask our witnesses to turn on their audio and make sure I can see your face and your raised hand while I administer the oath. Ask the witness that is present to rise so that he can be sworn in, who is physically in the room. And I will begin. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? I need to hear the witnesses louder, please, that are by virtual.
I do.
Let the record show the witnesses answered in the affirmative. Thank you. Gentlemen in the room may be seated. We will now proceed with witness introductions. Judge Lisa Foster is the co-director of the Fines and Fees Justice Center. She is also the former director of the Office for Access to Justice at the Department of Justice and retired California state judge. She previously worked as staff attorney at the Legal Aid Foundation of Los Angeles, the executive director of California Common Cause, and was of counsel to the law firm of Phillips and Cohen. Ms. Soto is a resident of Colorado, where she has worked in nonprofits for over 2 decades. She immigrated to the United States nearly 21 years ago from the state of Michoacan in central Mexico, and is a mother of a young man who had court-imposed fees imposed during a juvenile proceeding. Timothy Head is the executive director for the Faith and Freedom Coalition prior to joining Faith and Freedom. Tim worked in public policy as the district director for a member of the Texas congressional delegation. He also has served as chief of staff and as policy advisor to members of the Texas legislature. Before working in public policy, Tim served as a missionary in Asia, the Middle East, and Europe, and worked on staff at Antioch Community Church in Waco, Texas. Professor Harris is a sociologist and term professor at the University of Washington Presidential. She has written extensively on the impact of juvenile fees and fines and have on families and overall effect fees and fines have on over-incarceration. Her book entitled A Pound of Flesh, Monetary Sanctions as a Punishment for Poor People is widely considered to be the foundational text on fees and fines. Ms. Woog is executive director of Texas Fair Defense Project. Prior to her current position, she was the co-founder of the Texas Justice Initiative and served as a policy director on the Texas House Committee on Criminal Jurisprudence in the Texas legislature. Please note that each of your written testimonies will be entered into the record in its entirety. Accordingly, I ask you to summarize your testimony in 5 minutes. There is a timer in the Zoom view that should be visible on your screen. Judge Foster, you may begin. You are now recognized for 5 minutes. Welcome again.
Thank you, and good morning. Thank you all for holding this important hearing. Right now, as we speak, fines and fees are devastating the lives of millions of Americans.
Judge, can you speak a little louder? Or we'll try to make sure that yes, could you speak into the mic? Thank you.
Can you hear me now?
Better.
Good.
Better.
Across the country, people, including children, who are convicted of minor traffic and municipal code violations, misdemeanors, and felonies, are assessed fines and fees. Hearing a lot of data that Can you all hear me?
Yes, we can hear you.
Okay,
Yes, Judge, we can
sorry.
hear you. If you continue, please.
Thank you. When people are assessed fines and fees and they cannot afford to pay the full amount imposed, they are punished with aggressive and often unconstitutional collection practices. The result today is a deeply flawed system of monetary sanctions that it exacerbates poverty, widens racial disparities, and diminishes trust in our justice system. Though fines and fees are often charged together, they are not the same and they do not serve the same purpose. A fine is a punishment for violating the law. A fee has nothing to do with punishment or accountability. Its sole purpose is to generate revenue to fund government. In other words, a fee is a clever rebrand for a tax, and taxes have no place in our justice system. The justice system is a core government responsibility. It is supposed to serve everyone, and it should be paid for by everyone. Let me give you an example of how this works. Today in California, the fine for a simple traffic violation is often $100, but the legislature has added an additional $390 on top of that $100 fine, and those $390 in fees fund everything from the Fish and Game Service to the Office of Emergency Management. The impact of a nearly $500 ticket on the average American is catastrophic. According to the Federal Reserve in 2019, 40% of Americans could not access $400 for an emergency. If they don't have $400, how are they going to pay a $500 ticket? And if a person cannot afford to immediately pay the full amount they owe, jurisdictions use a host of abusive practices to coerce payment, including incarcerating people who cannot afford to pay, suspending driver's licenses, vocational licenses, and vehicle registrations, making it impossible for people to legally access the very jobs they need to pay off the debt. They add late fees and interest and allow private collection companies to add an additional 40% to the amount owed. They refuse to restore voting rights until all fines and fees are paid in full. And they often keep individuals under supervision until their fines and fees are fully paid, and then they charge them an additional fee for remaining under supervision. Fines and fees do not burden all Americans equally. Policing practices in our communities of color, coupled with the demographics of poverty in the United States, means that state and local governments are attempting to wring fines and fees principally out of our most vulnerable communities, the communities hardest hit by the economic and health impacts of the COVID pandemic. Without question, fines and fees are a state and local issue, but they are a national problem, and there are federal solutions. Traditionally, when we think of the ways Congress can influence state policies, we think of carrots and sticks, and those can be used to great effect in this arena. The Driving for Opportunity Act, introduced in the House by Representatives Scanlon, Fitzpatrick, Moore, and Reschenthaler, is a great example. This bipartisan bill incentivizes states to end debt-based driver's license suspensions. Similarly, in 2016, the Justice Department provided grants to 5 states willing to pilot fines and fees reform. Congress could do the same and cause states to innovate and engage in reform. Congress could also mandate that the National Institute for Justice study state reforms to determine best practices. A particular problem in this arena is the dearth of data. In consultation with the Bureau of Justice Statistics, Congress could mandate that states that receive federal funding provide data so that we can fully understand the scope of the problem. And again, so the Bureau of Justice Statistics could analyze that data and tell us how to solve these problems. Finally, the Fair Debt Collection Practices Act, which governs private debt collection, does not apply to debt owed to a state. We should not allow state and local governments to engage in conduct that we have barred in the private sector. I urge you all to take action today. We in the advocacy community stand ready to help. Thank you for the opportunity to testify, and I would be delighted to answer any questions that you have.
Judge, thank you very much for your testimony. I now recognize Ms. Soto for 5 minutes. Welcome.
Good morning, Chairwoman Jackson Lee, Ranking Member Briggs, Chairman Nadler, Ranking Member Jordan, and members of the subcommittee. Mi nombre es Julissa Molina Soto. Como inmigrante, el inglés no es mi primer idioma, así que por favor tengan paciencia conmigo. My name is Julissa Molina Soto. As an immigrant, English is not my first language, so please bear with me. I'm a naturalized citizen from Colorado, where I raised my 2 kids as a single parent. We were a close-knit immigrant family. We managed okay until my niño, or my son, Juan, got caught up in the juvenile system. Juan was 14 when police arrested him for stealing toothpaste from a supermarket. He thought we didn't have enough money to buy the toothpaste, but it was wrong, and I felt ashamed. I also had no idea what his mistake would cost us. The court charged Juan hundreds of dollars in fines and fees, including $60 each week for a class about the consequences of stealing. Since we couldn't afford the application fee for a public defender, I had to help him myself. Since I didn't understand English very well at that time, my 14-year-old tried to explain, translate everything to me in court. As a child, Juan did not have any money, so I had to pay everything. I was making $19,000 a year working at McDonald's to pay the court. I was late on rent, sacrificed things like groceries, and took a second job. I left the house every day at 5 a.m., and sometimes I didn't get home until after the kids were in bed. At 15, they arrested Juan for a small amount of marijuana. I was surprised, but maybe I shouldn't have been surprised because I rarely saw him and his sister. I had no time for my kids. This time, the court fees were even more expensive. We had to take a weekly class on communication, which cost us $75 each time we will attend this class. If we miss a class because we couldn't afford the fee, they charge us another fee. Sometimes when I made payments, the total increased because of late fees. I begged the court for a waiver. I offered to clean the courthouse or do other community service. After years of working 2 jobs, I finally paid off almost $8,000, but the cost to my family was more than just money. I couldn't be a mother that I wanted to be, and my son still resents me for not being around when he needed me. I don't blame the system for one mistake, but the fees made everything much worse for my family. Last month, my state ended all juvenile fees, but most states still charge fees to youth in the legal system and their families. My son, Juan, joined the U.S. Army after high school and served 2 tours on duty in Afghanistan. He is now in the Army Reserves and has a daughter of his own. However, he still struggles because of the financial hardship imposed on our family. We still struggle with communication. My son went to fight for our country, and he's a good dad. It's our turn to fight for kids and families by ending these harmful fees and fines. Thank you for listening to me today, and I'm happy to answer all of your questions.
Ms. Soto, thank you for that very powerful testimony. And now recognize Mr. Head for 5 minutes.
Good morning. Thank you, Chairwoman. The discussion of fines and fees in our state criminal justice system is an exceedingly important topic. Surprising agreement on both the political left and political right. My remarks today will focus on the mounting consensus on from a conservative and libertarian perspective, which is not as often discussed, I think, in our national dialogue. The power to punish is the greatest domestic power a government wields. Scholars and judges have debated the purpose of this power for centuries, settling on four fundamental justifications: incapacitation, retribution, rehabilitation, and deterrence. A function that's notably absent from this list is revenue raising. However, the raising of revenue has never been considered one of the core functions for a variety of reasons. We've reached a point in many cases that is exactly what's happening. It's not illegitimate in some circumstances to expect a convicted offender to bear the cost of at least a portion of their own punishment in the criminal justice system. But when an enormous portion of local government's budget come from criminal justice fees and fines, we can reasonably wonder whether the quest for revenue has displaced one or all of the four legitimate purposes that I just mentioned. It's not uncommon for 10 to 20% of many cities' municipal budgets to come from criminal justice fees and fines. Chicago, as an example, in 2014, derived 15% of its city budget from criminal justice fees and fines. Conservatives and libertarians often wonder that a conflict of interest is developing in our criminal justice institutions. Too often, police officers, courts, and community supervision officers are put in positions to raise revenue from their respective jurisdictions through their day-to-day functions. This is something we should all be concerned about. Conservative point of view tends to be skeptical of oversized government budget. In the worst cases, this issue we're discussing today is a telltale practice of overreaching budgets. When law enforcement officers must serve warrants for a failure to pay fees and fines, they're less available to respond to 911 emergency calls. When courts schedule appearances for failure to pay fees and fines, court proceedings for more serious offenses can be postponed or rushed to judgment. When criminal justice fees and fines begin to ebb away at relationships between law enforcement officers and community members, we run the risk of converting our police force essentially into tax agents. We should not be putting our law enforcement officers and community supervision officers into such positions which divert from their primary mission as public safety officers, and it also erodes community trust, which I think is a critical element that we tend to kind of underestimate. Now, with all of this said, I think that we have to point out that reforms have been happening in states for the last several years. We at Faith and Freedom Coalition advocate in a multitude of states. In the last 3 years, we've touched about 20 different states on subjects related to fines and fees, and we're seeing progress being made either on the state level, state legislative level, and also on for local jurisdictions. And while I'm encouraged by this, I'm also concerned that federal efforts to incent or potentially to coerce such practices may actually have an adverse effect. So one of the reasons why we've seen the embellishment of fines and fees across the country is because we've actually had too many expenses absorbed by our local criminal justice system. So, and when jail populations explode, when court dockets explode, that has to be offset and in some way, shape, or form. And rather than raising taxes in a lot of jurisdictions, they turn to fines and fees. As the judge just mentioned, these are essentially user fees. Unfortunately, when the federal government comes in with grants to this effect, it actually can create a reliance by local jurisdictions on these grants that only last for a finite period of time, 3 to 5 years. And when that grant is removed or terminates, we see a very dangerous need or reliance on that money. And so we actually effectively end up either raising taxes or raising fines and fees at the end of these practices. So we believe that it's important for the federal government, for DOJ and other entities to be extremely judicious in the use of federal grants to be able to entice these local practices. Thank you.
Thank you, Mr. Head, for your testimony. Now I recognize Professor Harris for 5 minutes.
Thank you for the invitation to engage in this conversation with you today. Few aspects of the criminal legal system vividly illustrate the two-tiered nature and extent of punitive excess of the United States, as does the practice of monetary sanctions. I will spend my time summarizing a few emergent research findings. It is important to note that in some states, judges have actually been granted discretion to assess criminal defendants for the cost of their public defender. In other words, an individual who cannot afford to pay a lawyer is expected to pay for the lawyer that the state is constitutionally required to provide. Many jurisdictions charge per night fees for jail or prison stays, as well as costs associated with probation and other court-mandated requirements, such as electronic home monitoring. In most states, all monetary sanctions must be paid in full before a person is released from court supervision. In many states, people are unable to vote until all costs are paid. They must remain in constant communication with court officials about their living and financial arrangements. As noted earlier, people lose their right to drive related to non-payment. Then, if apprehended while driving with a suspended license, even to a job that might enable them to pay their debt, they face renewed incarceration and further financial sanctions. It is also important to note that monetary sanctions are frequently imposed in addition to incarcerative time. So on their sentencing day, people may get several days to months to years of jail or prison time, and in addition receive thousands of dollars in fines, fees, court costs, and restitution. So even when people have served their incarceration and their probation time, they still remain under the control of the criminal legal system. Many of these people are unemployed, unhoused, suffer from mental health problems and chemical addiction disorders. As a result, they become tethered to the criminal legal system for the rest of their lives because of this debt. As mentioned, in the juvenile legal system, we know that nearly every state imposes costs on children, many of whom cannot legally work, enter into contracts, and are mandated to attend school. Recent reports have found that these costs include billing parents or guardians for child support fees related to detention in youth and jail and youth authority facilities. Families are also charged administrative costs, as we've heard, for court processing and appearances. In addition, youth are charged fees and fines and restitution. Recent research using data from a large cohort of adolescent court-involved youth found that significantly greater percentages of non-white youth still owed monetary sanctions upon case closing relative to white youth counterparts. The study also found that penal debt significantly increased the odds of youth recidivating. In a recent study, we found statistically that poor communities and communities that are non-white carry more penal debt than non-impoverished or white communities. Furthermore, this debt is statistically associated with increases in future poverty, especially for Black neighborhoods. It appears that penal debt makes poor communities even poorer. A final area I will highlight relates to revenue generation, policing, and traffic stops. Because local governments have come to rely so heavily on revenue generated from fines and fees, traffic citations have become a tool for profit making. This pocketbook policing encourages police to use their authority and discretion to make pretextual traffic stops. These are judgment calls that often involve such things as faulty taillights, expired license tabs, or an air freshener improperly suspended from the rear view mirror. The racially disparate impact of monetary sanctions intensifies the aggressive policing of Black and Latinx neighborhoods because these racial groups typically find it more difficult to pay. The policy implications from existing research are clear. The federal government should use its power to attach conditions to grants related to state law enforcement and justice practices. We need federal leadership. Such conditions should mandate states to require current ability to pay hearings prior to assessment of fines and fees, desist from imposing fees on minors and their families for court processing, and relieve all outstanding juvenile debt, discontinuing suspending driver's licenses related to non-payment of court-imposed fines and fees, and reinstate all prior licenses that have been suspended related to non-payment, prohibit courts from issuing warrants related to non-payment of court fines and fees, impose caps on the amounts of revenue local and state jurisdictions can generate via fines and fees, and states must annually report by jurisdiction the amount of fines and fees, sentence owed, and related surcharges, interest and payment fees owed and collected. In closing, the system of monetary sanctions reinforces the United States two-tiered system of justice, one for people with financial means and one for people without. Within a society riven by so much inequality, a system of punishment based on economic resources can never be fair or just. We have alternative punishment and rehabilitative options. We just need the will to make these changes. Thank you for your considerations in my remarks.
Thank you very much, Professor Harris, for your testimony. And we're now delighted to yield 5 minutes to Ms. Woog. Welcome.
Thank you, Chairwoman and committee members, for this opportunity this morning. Good morning. My name is Amanda Woog. I'm the Executive Director at the Texas Fair Defense Project. We are a legal organization that fights to end the criminalization of poverty. And each year, our attorneys represent hundreds of people who are saddled with criminal debt that they cannot afford. We help people get out of this debt and on with their lives. We then work with our clients to take what we've learned from these experiences and push for greater systemic changes. Criminal fines and fees uniquely burden people who are low income, and even a few $100s of court debt will turn into a high stakes, years-long struggle to keep those expenses from landing them in jail. Because our policing and criminal legal systems disproportionately target Black people and other communities of color, fines and fees also operate as a form of racialized wealth extraction. Criminal court debt keeps people from getting back on their feet financially, living in neighborhoods with better schools, getting better jobs, and obtaining basic necessities for themselves and their families. When I get a traffic ticket, and unfortunately I've gotten a few in my lifetime, I get frustrated with myself, my husband teases me, and I pay the ticket. Life goes on. The same cannot be said for people who are living at the economic margins. With 40% of people in the United States unable to afford $400 in an emergency, a simple traffic ticket can quickly snowball into more debt, warrants, a driver's license suspension, and even arrest and jail. Several of our clients have gone on to serve as advocacy fellows with TFDP, telling their stories to lawmakers to help them understand how these policies can trap people into a perpetual cycle of debt, fear, and the constant threat of jail. Emily is a current client at TFDP who had more than $5,000 in criminal legal debt from her court case. She recently shared this testimony with the Texas legislature. She said, "The debt makes me feel like I'm drowning. I cannot afford things for my children. My son wants to go to summer band camp, but I have to tell him it's not possible. If he wants a new deodorant at the grocery store, I have to tell him no. You have to finish every last drop of your old deodorant first. I'm the sole caretaker for 2 children, and all of my money goes towards them. I never spend anything on myself. I embarrassingly wear shirts with holes in them. Anything I receive goes to my children. To pay my fines and fees, I've tried everything. I've even donated plasma to pay them. But every time I see my probation officer, it's never enough, and all she asks about is the money. This debt makes me feel like I can't be a good mother to my children because I can't provide for them like I want to. They should not have to pay the consequences for my actions. And the system should be focusing on rehabilitating people, not on debt that just makes it harder for me and my family." Perversely, criminal legal debt becomes more expensive when a person cannot pay because additional fees for non-payment or even fees for entering a payment plan end up adding up, and this cycle feels impossible to break for the people who are in it. We help people resolve their criminal legal debt through legal representation, but there's a huge gap in services that we simply cannot fill. Many people with criminal legal debt never had an attorney to help them if the underlying cause was a traffic ticket or a low-level misdemeanor offense. For people who did have assistance of counsel in their underlying criminal cases, the assistance ended when the criminal case was adjudicated, and the impacts of the debt continued. On average, it takes our attorneys 10 hours from start to finish to get a person's debt handled. Without a lawyer, most people with criminal legal debt have no realistic chance of getting unaffordable court fines, fees, and costs waived or reduced. That's why we need structural changes that do not create these unmanageable debt burdens to begin with. Fines and fees are also an unreliable revenue source for local and state jurisdictions. A recent study by the Brennan Center for Justice found that in addition to thwarting rehabilitation and failing to improve public safety, criminal court fees and fines also fail at efficiently raising revenue. Because punitive approaches to debt collection hamper people's ability to obtain employment and support their families, they likely have an even broader negative financial impact than these studies suggest. Here in Texas, we've been chipping away at user pay systems that significantly harm low-income communities, and I want to conclude by highlighting a recent bipartisan success. For years, Texas assessed a surcharge on some driving offenses in addition to the fine penalty. When a person did not pay the surcharge, which they often did not even know about, their driver's license would be suspended. And these surcharges trapped millions of low-income Texans in debt without licenses. In 2019, the surcharge was repealed with support from a diverse coalition, including ourselves, the Sheriff's Association, the ACLU, the Hospital Association, Goodwill Industries, Texas Public Policy Foundation. More than $2 billion in surcharges were relieved, and 1.5 million people were immediately able to get their driver's license back. This was a bipartisan victory. The bill passed unanimously in both houses of the Texas legislature, and it was signed into law by Governor Abbott. More recently, Texas has abolished a number of juvenile fines and fees just in this past legislative session, again, with bipartisan support. Thank you so much for the opportunity to speak today, and I'm happy to answer any questions from the committee.
Thank you very much for your testimony. Now we will begin the questioning under the 5-minute rule, and I will begin by recognizing myself for 5 minutes. And I am very appreciative of the testimony of the witnesses and would ask them, because I have so many questions, for their succinct response so that we can get as much from you as we need to. As I indicated, this is an important hearing so that we can legislate, and we need to hear you, of course. Judge Foster, let me start with you. In your testimony, you specifically make the point about fines and fees are not placed upon Americans equally, and in over-policing communities, the most vulnerable people of color are really targeted, as one of our witnesses has indicated. And so I am interested in what you believe Congress can do to stop that tide as it relates to state actions to a certain extent, and then what would be the level of fines and fees levied on the federal level, and how that can be steered in the right direction so the most vulnerable are not the victims twice in terms of trying to get justice in the justice system. And when I say that, meaning that everyone accused and not accused are supposed to have justice in our system. So if you would respond to that, I'd appreciate it.
Certainly. Let me start with the question of racial disparities. There's no question, as I think you and many of the witnesses have recognized, that there are racial disparities in the justice system, and those are pronounced when it comes to monetary sanctions. One of the most important things that Congress could require immediately is data. We don't have very good data from local and state courts about exactly what's going on. And that's quintessentially something that the Congress can do, and the federal government has an important role. As I mentioned, the Bureau of Justice Statistics exists for the purpose of gathering justice system data from the states as well as the federal government. But we don't have good data about the racial disparities in the system. The best data that we have, a meta-analysis that was done at Stanford, demonstrates unequivocally that Black drivers are stopped 20% more frequently than white drivers. Once stopped, Black drivers are given a ticket 20% more often than white drivers. Hispanic drivers are given a ticket 30% more often than white drivers. But we know that about some places, we don't know that about every place. So data is a key factor. The second is, once we have that data, to make sure that we're enforcing the laws that prevent police from disparately policing. Some of that may also include some experimentation. We're learning around the country about alternatives to an armed police officer enforcing traffic laws, for example. And one of the things that the Justice Department could do is study places around the country that are moving to alternatives, unarmed traffic enforcement, and determine whether that works, whether that's something that other states could adopt. Those are things that the federal government does best. It looks at what's happening in the states and can study those, gather data, and then promulgate best practices to the rest of the country. So that would be my answer with respect to some of the things Congress could do on racial disparities.
Thank you
With
very,
respect to
thank you
the
very
federal
much,
system-
Judge. Thank you
Sure.
so very much. Let me, I appreciate it, and we'll continue our dialogue. Let me ask these questions to Professor Harris. In just the past few years, there have been a number of high-profile police stops that involve warrants based on a fee or fine. Can you describe how non-payment of a fee or fine can lead to an arrest and therefore a loss of income? And I'm going to give 3 questions back to back. So that is for you, Professor Harris. And Ms. Soto, let me acknowledge that your son is serving his nation in the United States military. We thank you for that, which should be an indication of what happens to vulnerable people. And yet these people are worthy Americans, Americans committed to serving their nation or committed to being citizens that contribute, but yet they're burdened by these fees. So you did so much to support your son. Can you describe in greater detail what the long-term consequences of the imposition of fees and fines had on your family? And then, Ms. Woog, thank you for exposing Texas and what continues to go on right now today as we sit here in this room. But it sounds as if they have been moving in the right direction. Can you describe in greater detail how Texas and other states have reformed how fees and fines are imposed, even in the backdrop of so many who have suffered? So the first answer should come from Professor Harris, then Ms. Soto, and then Ms. Woog. Professor Harris, and can you be concise in your response, please? Thank you.
Sure, thank you for that question. To be concise, when people in some jurisdictions, the one key issue is that there's disparities in the ways in which fines and fees are implemented and monitored across counties, municipalities, and states. So there's no consistent set of practices. But in general, in many jurisdictions, if people do not pay, in some jurisdictions, if people do not pay their fines and fees, they will have an warrant issued. Many times people will receive a summons to appear in court if they have not made payment. And if they fail to receive the summons, a recent study published in the UCLA Law Journal found that many people do not even receive the summons because they're of wrong addresses or homelessness. Or people receive the summons and they're scared to get incarcerated because they know they don't have the money. So if they don't appear at the summons, a warrant will be issued. And these warrants do not indicate to the police if it's a violent issue or if it was just non-payment. And then people can be pulled over. And we've seen when we have that contact in our communities, a recent study found that Black men have a 1 in 1,000 lifetime risk of being killed by police, 1 in 1,000 lifetime risk. So this warrants related to non-payment increase the likelihood of interactions with police, increase fear, anxiety, trauma, and even the possibility of death in our communities.
Thank you so very much. And Ms. Soto, the impact on your family, the long-term impact on your family.
The long-term impact on my family, like I said in my testimony, is that my son still resent me and my kids resent me because I was never there for them. He got arrested twice after that for having a small amount of marijuana. So I couldn't be the mother that I could be. No communication whatsoever. I was working 5 a.m. to 10 p.m. trying to pay these fees. And in the meantime, we got evicted also once because I had to choose between paying those fees or paying my rent. We still paying those consequences because still my kids resent me still till now. And they say, Mom, you were always working. You were never there for us. So I feel that by punishing not only the youth, you're punishing the whole family, the family as a whole. His sister struggled from that. I struggle from that. And what happened with these fees is that you separate families. You separate families because somebody has to pay these fees. These kids are young, so it imposes all those fees on the parent. And sometimes when you're a single parent, you're going to struggle to make it on your own. And like I said, I'm not blaming the system for one mistakes. I'm not blaming the system for me being a single mom, but I am asking the system to take into account on all those things. You're trying to fix one thing by imposing those fees. Supposedly, maybe the youth are going to learn the lesson, but you're
Thank you.
separating families and evicting families.
Thank you so very much. We have to respond. Ms. Woog, very quickly, thank you.
Yes, thank you. To your question about the reforms that we're seeing on the state level in Texas, I mentioned the repeal of the driver responsibility program, the abolition of some juvenile fees. We've also seen advances made to provide procedural protections for people, such as requiring ability to pay hearings. The problem with reforms like that is a lot of times they require the assistance of counsel. And as I mentioned, there's a huge gap in legal services. So some of the exciting experimentation that we're seeing in Texas actually occurs in a lot of local jurisdictions, where we're seeing local courts and counties trying to think of more effective and efficient ways to collect debt initially. But really important to tied to that is to allow people who are unable to afford to pay their debt to get into court quickly and resolve it by other means. And that kind of local experimentation is one of the more exciting pieces.
Thank you so very much. Ms. Sparks, for 5 minutes.
Thank you, Madam Chair. I agree with Judge Foster that the justice system is a core government function. I also do not disagree that California has very high taxes and fees. I also agree that fees is really a form of regressive taxation. The issue I have generally, is it a responsibility of the federal government to bail out states with bad policies? Because ultimately, if you do that, you punish the states with good policies and make them pay to the states with bad policies. And it seems like it should be a responsibility of constituency of that state to elect good government, to not vote for them and replace us with better people if they don't like policy, so they can move to other states. And we see a lot of this happening. But I also, as a gentleman from New York mentioned that 14th Amendment didn't exist during the time of the Federalist Papers. The 16th Amendment doesn't exist too, but the Supreme Court recently also confirmed that excessive fines clause applies to states, and it seems like this issue should go through the judicial system. It would be a better approach, but if the federal government has to do something, it seems like we talk a lot about carrots, and I think Judge Foster, you mentioned carrots and sticks. What kind of sticks? Maybe we should look states maybe shouldn't get some money for something instead of giving them the money. What is examples of few sticks you can give us to make sure that the states, would having bad policies, are not doing that instead of keep bailing them out?
Certainly. And let me just say that I gave California as an example, but every single state in the country and many municipalities within those states charge excessive fines and fees. This is a problem everywhere. It is not just a problem in some states. It's a problem in every state.
So just the scale of problems is large in some states, but I don't disagree with it. But just quickly, if you can briefly mention a few things.
Sure. With respect to sticks, let me give an example. When Congress determined that, for example, the speed limit across the country should be reduced to both conserve gas and protect lives, Congress did that by conditioning the receipt of federal dollars on states lowering the speed limit. That's a stick. We could do the same thing with respect to the money that Congress has appropriated through Justice Department grants, money that goes to the states. And we could say to the states, for example, if you want those federal dollars, then you have to collect data. If you want those federal dollars, you have to stop suspending driver's licenses for unpaid fines and fees. If you want those federal dollars, you need to do an ability to pay assessment before you impose a fine. If you want those federal dollars, you have to provide counsel, which the Constitution requires, without charging people a fee for that counsel. Those are the kinds of sticks that the federal government could use.
Right, I just, it seems like government, all we do is just collect data and data and data and report. And it seems like I've been in a state government too, and we just collect data. It's all about collection data, but I would like to get some really real policies. We have discussion. Maybe, Mr. Head, you have some other thoughts that you have, from libertarian perspectives, because I do understand that excessive fines really, can have adverse effects on people who do not have money, and the system can be stuck against someone who doesn't have the money, and it's very bureaucratic and expensive. So what other thoughts you have? What is there is a function federal government should have, or should be really just purely go through the judicial system?
Well, I wouldn't say that I have specific examples of sticks. What I actually am even more concerned about is the inadvertent, in essence, sticks that end up coming by dangling carrots and finding overreach. So when you, as I mentioned earlier, we have burgeoned our either federal or state justice systems over the last particularly 40 years, 35 to 40 years, and have introduced different federal grants to either study or to implement programs or to provide services, but the grants are never offered in perpetuity. So 3, 5, sometimes maybe like a 7-year grant. But when that is removed, the expectation for that service or facility doesn't go away. Also, the expectation in a community doesn't go away.
It's a big challenge. I mean, the dependency, and it's a huge challenge. I've seen it as a state legislator, I've seen it. But is there any solution that really should go through the judicial system, and, government should be sued in the court of law for these excessive fines, which apply to the states too. So do you believe that is the best approach, or how it should be dealt with?
Well, it's a longer, a longitudinal approach, but the reason why I spend much more time in state capitals than I do here is because that's actually where we see the most effective and most innovative practices.
People just have elect better legislators, I guess, better governments,
right. and call for better policies on that either local or state level.
Thank you. I yield back.
I thank the gentlelady, and now pleased to recognize the chairman of the full committee, Mr. Nadler, for his questions for 5 minutes.
Thank you, Madam Chair. Ms. Soto, you should blame the system because it has greatly failed you and your family. Judge Foster, the use of fines and fees has increased steadily over the last 3 decades. Despite a constitutional requirement to do so, many courts never consider a person's ability to pay. In what ways does the failure to conduct ability to pay determinations affect the assessment of monetary sanctions?
So it's very direct. When fines and fees are imposed, for example, on a family like Ms. Soto, rather than looking at what her economic circumstances are, the court just imposed a flat amount. Let me talk specifically about fines. The purpose of a fine began as an alternative to incarceration. And the purpose is really both to punish and deter, right? If you think about a speeding ticket, we want you to think about it before you speed again. So we want the monetary sanction to be enough so that you'll think twice before speeding, but not enough to bankrupt you and your household. And that argues for the amounts to vary based on one's economic circumstance. And so instead of doing that, and saying to someone who's in Ms. Soto's economic circumstance, a minimum wage worker who at $7.25 an hour, the federal minimum wage, is $400 for a ticket is literally a week and a half of work. Instead of saying we're going to charge you a flat amount, you say what's it going to take to deter that person from doing that consequence again, and it's less. And their economic.
Do you think that fines maybe? Do you think that fines maybe should be assessed at a percentage of a person's income?
I think that would make a lot of sense. That's exactly what happens in most of Western Europe and South America. And we can do it in lots of different ways. We can say, this is the standard amount. And if you earn less than that, we're going to adjust the fine to compensate for the fact that you earn less than that. That would make a lot more sense.
Thank you. Professor Harris, compared to the amount they actually receive, courts spend massive sums of money attempting to recoup unpaid debt and create severe hardship while doing so. even garnishing poverty-level income like SSI benefits to obtain payment. These fees then compound. Additional sanctions are imposed as a result of failure to pay, prolonging both spending on recoupment and the hardship for debtors. What are the financial and human costs of pursuing unpaid debt? I think we've heard some of that today.
My research team and I interviewed over 500 people across 8 states in the US, and this system is pervasive across the US. I do want to establish that. And what we found is that people receive a bill, their monthly bill owed to the court, and every month for many people that bill increases because of payment costs, collection fees, and interest. And so when that bill keeps coming and people feel like they're drowning, it creates a great deal of stress, emotional stress and strain on families and children. Where, you know, some people say they can't go outside, they're afraid to go outside because they'll be arrested. It creates this tethering to the criminal legal system where people have to constantly report. They have to miss work to report to court, to sit in the courtroom all day, right? Many courtrooms require you to report at 8, but your case might not be heard till 3. It'll put strain on garnishment of your wages. And even income checks can be taken for payment in many jurisdictions. So it's a great deal of economic, emotional, health, criminal legal stress for individuals and their families.
Thank you. Ms. Wong, monetary sanctions raise serious constitutional questions, including around the 8th Amendment prohibition on excessive fines, 5th and 14th Amendment due process rights, and 6th Amendment right to counsel. How do court fees affect due process and the administration of justice for people who are accused of crimes? And how do you think we might fashion the kind of legislation that we were talking about a moment ago to base fines on people's incomes in a way that wouldn't violate constitutional rights?
Thank you for that question. You're right that in theory there are, multiple constitutional amendments that should protect people from criminal debt burdens having the kind of impacts that we've discussed today. But unfortunately, in our work, what we see is that most people don't have access to assistance of counsel to actually assert those constitutional claims and challenge their criminal legal debt from a constitutional perspective. And so I agree with Judge Foster that it's really on the front end that we need to be addressing these issues. We're right to keep focused on the constitutional issues, but in these millions of individual cases where people do not have counsel typically, it's very, very difficult to assert those rights. So I agree that on the front end, we need to be thinking about how to issue fines that are commensurate with what a person is able to pay and doesn't create the kind of burden that carries with them for years and really has this devastating impact on themselves and their families.
Thank you. Madam Chair, I ask for unanimous consent for a letter from the National Legal Aid and Defender Association describing the harm fees and fines may impose, and a report from the Brennan Center for Justice entitled "The Steep Costs of Criminal Justice Fees and Fines" that undertakes an empirical analysis of the fiscal effects of fines and fees be entered into the record.
Mr. Chairman, without objection, so ordered.
Thank you. I yield back the balance of my time.
Thank you.
Thank you, Madam Chairman. I appreciated the suggestion that fees and fines should be adjusted based on income. Judge Foster, do you know if the federal courts adjust fees and fines based on income?
So the federal government doesn't impose many fees, certainly not at conviction.
Judge, I know you'll appreciate that. I just need you to answer the question, if you can.
I am trying.
Let's get around. Does the federal government, it's pretty simple, do they do that?
Well, they don't need to if they don't impose them.
All right, thank you. Does anybody know besides Judge Foster whether the federal courts adjust fees and fines based on income? We'll have to pursue that and find out for sure. I think it's a good suggestion. One of the things I noted, having worked as a felony judge in the state system, was how many departments would get federal grants and they would start offering what the federal grants would require, the grants would go away, and they're looking for income streams to replace what the federal government lured them into doing. And people would say, hey, we like to do that, so you got to come up with a source of revenue. The locals in the state couldn't afford to provide more, so they looked at fines and fees. So I think all of it needs to be looked at. I'm particularly concerned, since this is the federal government, about the forfeitures. I know Judge Foster didn't think fines and fees are a problem in the federal system, but they have been, and I've seen them be. So we have a little different perspective on that. But especially when the federal government engages in forfeitures where they have decided, gee, we can't convict somebody, so we'll just go in and take his property, and they end up taking property of the family that was not involved in any wrongdoing. It destroys their way to make a living. I wondered, Mr. Head, have you observed anything of that nature from the federal government and problems with forfeitures?
Yes, sir. And asset forfeiture is a bit of a unique animal because it has federal implications that when applied also sort of brings local or state jurisdictions in. So it's sort of this hybrid practice that even when states may either reduce, or even a number of states now have abolished civil asset forfeiture, the federal government can essentially cooperate on a given project, and the assets that are brought in through that project are then split between the feds and that jurisdiction, state or local jurisdiction. So it becomes a problematic situation, and then the assets themselves frequently are used for programs, but as another witness alluded to, it's kind of by definition, it's an erratic, unpredictable income stream, so to speak, revenue stream for a government. So it's not only is it problematic on a property rights standpoint and a familial standpoint, but it also is not a reliable way to run any government program.
Well, there's an element of unfairness that you can often find, correct?
That's exactly right.
And that's my concern from a federal standpoint, is the element of unfairness. With regard to a reimbursement as a fine or fee to a defendant in federal court, since federal court is where we clearly have jurisdiction, I have seen pre-sentence reports come back with egregiously outrageous amounts of alleged reimbursement that overwhelms the defendant. They can never pay it back, but the prosecution felt good about having such a high number. Have you seen things of that nature in federal court?
Yes, sir. The practice is that practice in and of itself tends to be a bit erratic in different jurisdictions across the country. Some regions, some districts are more maybe cavalier in that practice than others. But you're exactly right. Even when I mean, it's not uncommon actually for people to for defendants to actually be acquitted of all or many of the charges, but still have to levy the kind of bear the burden. Again, you know, I think of these things almost as user fees. You rented in essence our defense counsel, our courtroom, you know, our stenographer, et cetera. And so even if you got off, we're still going to.
If you're stuck on one, and I see my time's expired, but I would, Madam Chair, I would like to see this also pursued because it's not uncommon from what I've seen to have the pre-sentence report include an amount of restitution that seems very high. Maybe it's unlimited, but I would hope maybe we could look at that at some point. But I appreciate having the hearing. Thank you.
Mr. Goldman, while this hearing is not on that, you are absolutely right. It is an issue that this committee should take up. And I was here long enough to have been with Mr. Hyde when we were also discussing the forfeiture challenges that we face on the federal level. So, and we probably are long overdue. And so let us look forward in a bipartisan way to look at those issues. I thank you for raising them, former judge. It's now, I will recognize Ms. Bass for 5 minutes.
Thank you, Madam Chair. And let me just thank you so much for holding this hearing today. You know, as the gentleman mentioned, restitution and fines and all of this, I just don't understand the point when we do this and have the fee or the restitution be so high. We know the person's not going to be able to pay it back, and it just sets them up. And it's kind of like the continuum that we were talking about last week with people who are released from prison and have nowhere to go. This is an example of the roadblocks that we set up, and we concentrate these people in certain neighborhoods, and you lock them out of the economy, and then you wonder why they reoffend. So this is part of that continuum and why I appreciate us having the meeting today. I wanted to talk about the impact on children, because on the report from the committee, it says that in 2016, Philadelphia netted over $500,000 from parents of children that had interacted with the JJ system, the juvenile justice system, and that the inability to pay for the legal guardian to pay a nightly rate for the child's detention can lead to a violation of probation or even facing extended periods of time. So children, and this is what I'm asking the panel, Professor Harris, Ms. Foster, children wind up spending time in jail because their parents can't pay a fine. I want to know the data, how many children wind up being incarcerated, and then when they do get out, what does their future hold? Has anybody studied this? We had this policy in Los Angeles County where the parents had to pay a nightly fee, basically for room and board, and we abolished it. We stopped doing that in LA County. And so I want to know, can you talk about data and long-term consequences? When you put kids in the system, how on earth do they get out?
Right. Well, the data is bare, honestly, on studying many of these issues and processes, because we don't have data on numbers. As Judge Foster indicated, we don't have a federal set of numbers across all of our states, but we also don't have the data within the states to be able to do these analyses. What we do know, I referenced a study that was done by Alex Picaro and his colleague, that when youth have this debt, that it significantly increases the likelihood of recidivism. So we know that the debt leads to youth reoffending in their communities. We know from qualitative studies, the stress and what Ms. Soto described here, the strain put on families, and it's the strain for generations. It's not just that moment. We know that when young people are incarcerated, they are surrounded by folks who don't support rehabilitative entry. Right?
Well,
We know that education is poor and quality in these systems. And so when they come up, they're set for failure. We're doing an analysis of some of the interview data, and many of the adults that we interviewed talked about the juvenile debt that followed them into adulthood, and consequences, criminal legal consequences for not paying that juvenile debt once they are adults. So we're increasing, we're moving towards this direction to finally study the juvenile realm. We just don't have the data, and we need a bit more time to really dig in and understand the consequences. But it's clear, it's problematic. It's not helpful in any way.
Well, I don't see how it's not child abuse. I don't know if Rep. Foster, if Mrs. Foster Wong, or if you
Now,
want.
let me just add one thing, and that's to emphasize what Professor Harris said. In many jurisdictions, if the debt cannot be paid by that child's family, the debt follows the child into adulthood. So when the child becomes 18, they're saddled with debt. In Florida, for example, they prospectively suspend a child's driver's license. So if a child gets in trouble, even for something as minor as Ms. Soto's child stealing a tube of toothpaste, the child cannot get a driver's license, which means the child can't find a job to pay back the debt, even if we thought it was a good idea for kids to work.
Let me ask you, I did a study about this 25 years ago or so, and in LA, it started with tickets for truancy. So if you were late to school and the police were surrounding it, they could give you a ticket for truancy. It could go into a warrant. Do you find much of that? Now, we ended that in LA as well. Do you find much of that around the country, ticketing for truancy?
There are tickets for all kinds of things. And there was actually just a study done by the Juvenile Law Center about children in municipal courts for municipal code violations. These are adult courts. They're not juvenile courts, but they're children who may violate some kind of a municipal ordinance, a noise ordinance, or being in a curfew ordinance or a truancy ordinance. And then they end up in adult court without counsel, and fines and fees are imposed upon them that, as we said, saddle or stay with them for the rest of their lives. And that's just antithetical to the whole way that we are supposed to be thinking about juvenile justice.
Thank you very much. And thank you, Madam Chair.
Thank you. Gentleman from Wisconsin is recognized for 5 minutes.
Thank you, Madam Chair. Mr. Head, I was going to kind of direct some comments and a couple questions your way. Being a former state legislator and doing a lot of ride-alongs at the circuit court level, I was often intrigued and interested to see the banter that goes on between some of these judges and the defendants that are before them. A lot of times it's about the wherewithal and whether or not the defendant actually could pay for some of these enhanced fees. And probably the best example of that is state legislatures who have a lot of control over this process at the state level, oftentimes will continue to impose fees that, quite honestly, the defendant is going to be unable to pay in the long run. And you're not going to send a police officer to somebody's door to try and collect these fees later on. So you end up trying to jump through all these hoops to devise all these systems to pull those dollars back. So my first point is, with a rapid expansion of the federal grants and what we're seeing, the strings attached as those dollars move to the states, it seems to me it's just a better place to manage this kind of at the state and local level, whether it's a municipal court or a circuit court. What's your thoughts on that?
Well, I categorically agree. One of the pieces that I think I'm encouraged with. So, obviously, Faith and Freedom Coalition, we do work on the federal level, but in a lot of states as well. About 20 states this year that will engage legislatively. I'm seeing a significant uptick in community review boards, which essentially are local law enforcement, county or city law enforcement that then sort of invite community leaders to have an ongoing, it's a chartered organization that receives input from that local community. And I think that I'm actually very encouraged by the progress. I mean, I know of 6 or 7 cities that have implemented that just in the last 2 or 3 months here. Every system not only is different, but also every community has very pronounced different needs and dynamics. And so I think it's really, really important for us to recognize and kind of devolve the decision-making process to as local as possible, and conversely avoid federal or national prescriptive approaches that either are going to be inapplicable in a lot of places or truly will diverge or divert, a lot of this local decision-making process.
Yeah, I mean, it goes against kind of what we want the system to actually accomplish, which is to hold these individuals responsible for either negligence or, obviously, in some instances at the federal level, breaking they're criminal defendants that are breaking the law. But the idea is that state and local authorities certainly would be better served if we would allow them to make these decisions. I'll just kind of go in a little bit different direction. Oftentimes we would have individuals that just aren't paying child support. They're just, they're way behind, they're in the rears, and they come before the circuit courts in Wisconsin, my home state. And a lot of times the circuit court judges would simply say, let me get this straight. You can't pay your child support but you've got a $9 pack of cigarettes in your pocket right now. You know, there's oftentimes kind of that type of management, that level of management and relationships that are built with defendants that I think would serve us much better. And at the federal level, even further removed, you know, I just don't see how this makes a lot of sense. So I thank you for being here today, but I think the detachment we see from the federal government to being able to manage this type of system just doesn't exist. So.
I agree with that, and I also think that the use of or the alternative of community supervision, of community service, is underutilized. I think in a lot of contexts for people's inability to pay. But you know, the specific place for people to be able to serve obviously needs to be driven by local either judges or potentially prosecutors to make recommendations as well. So I think there are ways to kind of marry. We would like to see more practices of things like that for alternative to pay, but even then we need to see partnership with local jurisdictions, so it's very, very important for us to be almost over aware of local input into these kinds of processes and procedures.
Thank you, Madam Chair. I yield back.
I thank you. The gentlewoman from Florida is recognized for 5 minutes. Then we'll move to the gentlewoman from Georgia, Ms. McBath, for 5 minutes.
Thank you so much, Chairwoman. Thank you, each and every one of you, for being with us today. And Ms. Soto, I just can't thank you enough for sharing your story. And I'm so sorry that you have been saddled with all of these fees and, this has become so problematic for you. But I really appreciate you sharing your story with us today. And Professor Harris, as Ms. Soto experience just shows us today, often the person who is paying the fees or the fine is often not the person who actually has done anything wrong. So Professor Harris, I just want to ask you, you co-authored a study that looked at the fine practices in 8 states, and including Georgia, which is the state that I represent. And you found that not only was there variation across the United States and to how these fees were applied, these fines were applied, but you also found that there was variation within each and every state. So in your view, were these variations consistent with that principle that our justice system should treat similar cases in the same way?
I mean, I think that we all have this broader notion that justice should be fair. And what does fair look like? It should be consistent, and there should be policies and practices that guide how decisions are made. And we found across our 8 states that there is so much variability within a courthouse, within a city, within a county, within a state across the United States. One example that we haven't talked yet about is that many jurisdictions impose mandatory fines and fees. So even if there's an ability to pay assessment at the front end, so people are impoverished, then judges have the discretion not to impose discretionary fines and fees. In Washington state, people are sentenced a mandatory $500, regardless of ability to pay. So $500 per felony conviction. So there's a lot of variability, and even ability to pay assessments won't apply to some practices. So it's important that we have this broader conversation about what is accountability, what is the point of punishment that the last person raised. If accountability means being able to meet some bar and standard, fulfill that punishment, and then move forward with your life, then we need to really assess fines and fees, because the vast majority of individuals who face the criminal legal system do not have the ability to be held accountable, even though that they want to. One consistent factor across all of our states and interviews is people who have been convicted, they wanted to serve their time
Thank you very much. I want to move on. Ms. Soto, did you feel that you or your son were really giving clear information about how much he was going to be fined for and how to avoid the late fees or the harmful consequences that you've experienced? And then after she gives that answer, I would love for you, Professor Harris, to kind of elaborate on that.
Yes, I felt that my son and I were clear that we were poor, that we couldn't pay these fines. I was also offering to pay to clean the courthouse or doing some community service hours with him because we did not have the money. But it seems that the system is set not to listen to communities of color. I feel that we get punished more because of our color, because of the language barrier. It was no language justice in here. I feel that my son and I were isolated through the system, and we were not given a chance to even speak about, how much they knew how much money I was making. So I think it's a great idea if they can impose those fees based on your income and not put a lot more pressure on us. Thank you.
Thank you for that. And so Professor Harris, can you elaborate on that for me, please, very quickly?
Sure. Again, that was one consistent finding across all of our 8 states is uncertainty, lack of knowledge, lack of what is that? What am I being billed for? Why does it increase each month? Where do I go to pay? How do I pay if I have multiple cases in different municipalities? There's a clear lack of understanding of this process of why am I paying because I already was in prison for several years? Why am I paying because I'm on probation? So a lot of questions that were unanswered by local courthouse clerks and lack of access to judges to ask those questions or attorneys for that matter.
Okay, thank you. Ms. Woog, some states have stopped the suspension of driver's licenses for those who've not actually paid a fee. Based on your work with clients, what effects does this have both for the client, their family, and their community?
I mean, the effects are absolutely devastating. In Texas, a driver's license is a practical necessity for people to obtain childcare, to go to work, to provide for basic necessities for their families. And what we see for people who have their driver's licenses suspended is either they pull back entirely. It's very isolating for themselves and for their families and can exacerbate existing mental and physical health issues, or they risk driving illegally, which then exposes them to warrants, jail time, family separation. And so that stress and that fear is internalized regardless of how someone deals with that situation and is absolutely toxic for individuals, their families, and their communities.
Thank you so much, and I yield back my time.
I thank the gentlelady. The ranking member continues to reserve, and now I'd like to recognize Ms. Demings for 5 minutes, the gentlelady from Florida.
Thank you so much, Madam Chair, and thank you to all of our witnesses who have joined us here today. Ms. Soto, I'm going to direct my question to you. Professor Harris talked about that it's important for the justice system to be fair. And that's a mouthful. I strongly believe that as someone who has served in the criminal justice system for almost 3 decades. And while we continue to make sure that the system is fair and even balanced, I think just as we are still working to form that more perfect union, it is still a major work in progress. But Ms. Soto, I think it's so important to hear the personal stories because as we do this very critical work, I think those personal stories are so powerful in terms of getting us to the place where we need to be. We just need to have the political will and really believe that we are working for a more fair and just system. I certainly am doing that. You spoke about a bit about that the fees imposed should be based on income. But I want to give you yet another opportunity. Our time has been well spent, but I want to give you another opportunity to make this appeal based on your own experience. How can we, as members of Congress, which is a pretty influential body, how can we support the efforts to make this a more fair and just system as it pertains to fines and fees?
Thank you for giving me this opportunity to speak for, those who don't have a voice, to be the voice of the voiceless. And I do believe that we must look at stories such as mine and see the impact that we cause not only to the state, but to the country. These are our youth. These are our new generation. My son went and fought for our country twice. So a lot of the times we're deteriorating children of color. And I feel that all these fees and fines is just a way to oppress our children of color. And I just don't understand why it's a system that don't, is in here is not about Republicans, Democrats, liberals. In here is about something that is real, that is happening to families. So I certainly believe that if we look at the person income and base that out of their income, that fines, I have no problem with that. I feel that that will be the solution, but not the same fees for all. I just don't think that everything applies to all. And I do feel that children of color get harsh punishment than children who are Anglo or other race and ethnicity. Thank you very much.
Thank you so much, Ms. Soto, for your powerful testimony. Madam Chair, I yield back.
All right. The ranking member reserves of the subcommittee, and now I yield 5 minutes to the gentlelady from Pennsylvania, Ms. Dean.
Thank you, Madam Chair, and thank you for hosting this important hearing. Thank you to all of our testifiers for your expertise that you are offering us today. Judge Foster, if I might begin with you. In 1983, the United States Supreme Court ruled that in Bearden versus Georgia, that someone could be sentenced only if he or she had the money and willfully refused to pay. But we heard today over and over about these debtors' prisons, and how they can force people to forego the basic necessities of life in order to avoid arrest. Judge Foster, what kinds of constitutional rights are implicated in the current imposition of fees and fines? I'm thinking of my own court system in suburban Philadelphia and those who are struggling under fees and fines that are unbearable.
Thank you for the question, and there are many. So as you mentioned, the Supreme Court long ago and consistently since Bearden versus Georgia has said that in the justice system, money cannot matter. It cannot be the case that we treat people differently in our justice system based on how much money they have in their pocket or their bank account. And yet that's precisely, as you indicated, what happens. In all over the country, people who cannot afford to pay fines and fees are incarcerated. They're going to jail because they cannot afford to pay, as well as the host of other consequences. So that is certainly one, and that's equal protection and due process. The second is the right to counsel. And what we see often is because so many state and local governments charge people a fee for counsel, people don't obtain counsel. Ms. Soto just gave you the best example. Here is a child who has the right to counsel. It's in the Constitution. And the Supreme Court said many years ago in Galt, children have the right to a lawyer in juvenile justice proceedings. But if a fee to apply to obtain counsel is imposed, and if a parent's told, oh, at the end of the case, you might owe hundreds, and in some states, thousands of dollars for your free lawyer, then parents are going to say to their child, no, we can't afford a lawyer. And so that child goes unrepresented. The Eighth Amendment, and several members have talked about the excessive fines clause. The Supreme Court, as indicated, just recently held unequivocally and unanimously that the excessive fines clause applies to the states. Yet we see states imposing excessive fines without, as the excessive fines clause requires, doing any kind of an ability to pay assessment. That is in the excessive fines clause. The state of Indiana's Supreme Court, when the case from the US Supreme Court was sent back to the Indiana Supreme Court, they developed a standard for determining when a fine is excessive. And part of that standard is whether the person has the ability to pay the fine imposed. And last but not least is due process. And that is someone's ability to understand the proceedings before them, to have the right to a fair hearing, and to have their voice heard. And that is being violated every day across this country.
Thank you, Judge, for that very thorough listing and powerful listing. And I want to reconnect to Ms. Soto. Thank you for your testimony today. I thank you for your son's contribution and service to our country, and therefore your whole family's service to our country. What an extraordinary story. Theft of a tube of toothpaste because he thought his mom couldn't afford it. And what I wanted to ask you is, if you don't mind, what are the long-term effects of your story, of the imposition of all of the court mandates, fines, fees, fear? What are the long-term effects for you and for your family?
The long-term effects for me and my family is that we don't trust the system. We feel that the system has failed us. I had to have a second job to pay all these fees, and I couldn't be the mother that I wanted to be. Therefore, I have to still pay that type of a punishment that your kids have towards you because you not being there as a mother for your kids. The three of us have to still go through therapy, and still we're spending more money because of what happened with Juan in the past. So we keep giving money to the system, a system that failed us when all of us have fought really hard for this country. The second job really ruined our job. The system failed us. I'm very afraid of the system. I don't believe in systems somehow, even though I have 2 decades working in the nonprofit world, giving back to my country because this is my country. My son fought to wars, and my daughter dedicated her life to the homeless. We still have some type of resentment toward the system. We just don't trust systems. Thank you very much.
Thank you for your powerful voice. I yield back. I see my time has expired. Thank you, Madam Chair.
Thank you very much. I'll now yield to Ms. Judy for 5 minutes.
Thank you, Madam Chair. My questions are for Mr. Head. While fines and fees can create problems if not administered correctly, they can also save law-abiding taxpayers from footing the bills run up by criminals. How could broad federal rules about fines and fees hurt the ability of states and localities to collect revenue from convicted criminals who drive up law enforcement and court costs?
Excuse me. I think that, as I alluded to in my opening comments, that I do think that there is a danger of overuse, but there also is a legitimate use for fines and fees, especially when in circumstances where very dire crimes have been committed, and also where long investigations or trials have been embarked upon, and so I think that there also is an inadvertent danger for Congress stepping into this from a federal level. Those are typically outlying cases, but can also be very profound cases. We're certainly talking about transnational cases and interstate cases. So I think that we need to be mindful that a kind of one-size-fits-all prescriptive approach on the federal side can not only not contemplate the hyper-local scenarios, individualized scenarios and communities, but it also can lack the elasticity for the extremely high-end cases that are outliers, but also those are the most expensive and most elaborate drains on our system and on the resources that are entailed there.
Yeah, and I'd like to further address the problems of using federal grants to change state policy, and I believe it's the role of state governments, not the federal government, to dictate, especially in this area of law. I represent Florida, come from the great state of Florida, and we've done a lot. When I was in the state legislature after the last 8 years that I was there doing criminal justice reform and looking at these issues like civil forfeiture and those type of issues. So I have great concerns when the federal government's going to address something that the states should have within their purview. As discussed earlier today, not every state faces the same issues when it comes to criminal law in general or fines and fees specifically. From your experience working in public policy on the state and federal level, can you give some examples of a one-size-fits-all federal grant requirements that hurt state law enforcement efforts in unintended ways?
Well, we just had a bit of a conversation on asset forfeiture that I think by a so again, the asset forfeiture process is allowed on the federal side, but also has been either reduced or greatly restricted on state sides. Actually, about 14 states in the last 4 years have either restricted or abolished asset forfeiture. And but ironically, by not having much treatment of the issue on the federal side, what generally happens on the state side is the federal investigators tend to partner with local or state law enforcement agencies, and so there's essentially a federal workaround. This is kind of the opposite of in some ways of what your question is. Federal inactivity has actually circumvented states' desires to reduce or curtail the practice of asset forfeiture. So while federal action can certainly have an undesirable effect, federal inaction has actually been problematic. In essence, the feds not having their household in order, so to speak, has actually limited states' rights.
Can you speak about the use of fines as an alternative to incarceration and how that could be negatively impacted by federal rules limiting fines?
Well, I think that yet again, if we can contemplate or allow for local ability to treat local issues, we not only find, for instance, in North Carolina, just last week I was having meetings about North Carolina considering. Right now, there's a prohibition against community volunteering, basically, to supplant or replace payment of fines. And so North Carolina is actually strongly considering reversing their state policy. But New York also has a similar prohibition in place. What we would like to see, for us, is to be able to go to the sort of outlying states to be able to address these kind of unique approaches, because I think that there's what tends to happen whenever we have a prescribed federal approach or nationalized approach is that we contemplate the kind of the norm, but inadvertently we marginalize the exceptions, and then the exceptions can actually become exacerbated. So, once again, it's important for us to be able to have the ability to customize approaches, not just prescribe.
Thank you for being here today. My time's expired.
I thank the gentleman for his questioning. The gentleman yields back, and I'm pleased to yield 5 minutes to the gentlewoman from Pennsylvania, Ms. Scanlon.
Thank you, Madam Chair. And thank you to our witnesses for being here today. Professor Harris, before coming to Congress, I participated in the defense of children in what's become known in Pennsylvania as the Kids for Cash scandal. And for those who aren't familiar, between 2003 and 2008, hundreds of Pennsylvania teens were sentenced to a for-profit detention center in which 2 juvenile court judges had a financial interest. Those sentences usually occurred after the young people were pressured to waive their right to counsel or confess to crimes that they didn't commit. In one of those cases, after the court's conduct was declared unconstitutional and our client was released, her parents got a hefty bill from the county for the cost of her unconstitutional detention. Professor Harris, in your testimony, you spoke about fees like this being imposed on children and families, even when the children are later cleared of misconduct. Can you very briefly highlight what we might do at the federal level?
Thank you for raising that important point that we haven't talked a bit about, but that there's profit making off of these charges and fines and fees for minors and for adults. And it creates this perverse incentive, as we've seen for some judges, but for other officials of the criminal legal system to try and find ways, right, to keep making profits. We also have a lot of contracts with private entities, and so it's not just about private facilities or private jails or prisons. It's about private entities that are infused within local courthouses, jails, probation officers, and prisons that are allowed to make profits off of a literal captive audience. I'm not clear on what the federal government could do, and I do think that contracts should be made publicly available so we understand the degree of profit making and kickbacks that local governments are getting from private entities in these relationships.
Thank you. I think in that case, actually, what the federal government was able to do involved prosecution for wire fraud, and those judges ended up in jail. Judge Foster, thank you for mentioning my bill, the Bipartisan Bicameral Driving for Opportunity Act, which we successfully passed out of this committee earlier this year. We know that court-imposed fines and fees can land people in an endless cycle of debt. And if they can't afford to pay the costs immediately, they can face harmful consequences like the suspension of government-issued IDs like driver's licenses, and about 11 million people nationwide have suspended driver's licenses for unpaid fines and fees. I understand that some states and localities have begun implementing laws to end the suspension or revocation of licenses for unpaid fines and fees. Why are they reconsidering that, and what role can the federal government play to incentivize states to enact these reforms and end this practice once and for all?
Thank you for your question, and thank you for your sponsorship of the Driving for Opportunity Act. It is important. So the states that have stopped suspending driver's licenses for unpaid fines and fees, and there are several, we are proud of the fact that for as little as 4 years ago, there were only 3 states that did not suspend driver's licenses for unpaid fines and fees. And today, 22 states have engaged in some form of reform. And that's important. But the reason that they've enacted reforms and stopped the practice is because it's counterproductive. It doesn't take most people much time to understand that if you want someone to pay you money, taking away their driver's license, their means of getting to work, is not a terribly effective way of collecting that money. And states have understood that. They've also understood the much larger economic consequences to the states. In the United States today, 30% of jobs require driving as part of the job. And I don't mean just Uber and Lyft drivers, but if you think about it, a plumber, an electrician, a construction worker, a Verizon repair person, not to mention long-haul truckers. All of those jobs require a person to drive, and that requires a valid driver's license. And if we take that license away, we make our states less productive. In addition are the costs of enforcing driving with a suspended license. In many places around the country, driving with a suspended license is the #1 criminal charge. That means that the system is spending a lot of money prosecuting people whose only crime is to be poor. So what can the federal government do? Exactly what you've proposed.
Thank you for that. And I see my time has expired. The gentlewoman from Missouri is recognized for 5 minutes.
St. Louis, and I thank you to our chairwoman for convening this important hearing. There is a daily trauma that we experience in my town, in my home, St. Louis. In my community, we have many municipal governments, and many have their own local government, their own local police force, their own local revenue stream. Each of these municipalities relies heavily on systems that incentivize raising revenue off of targeting people living in poverty, specifically Black people, through traffic stops that lead to fines and fees. It does not have to be this way. I personally know many exemplary public servants who serve in our St. Louis municipal governments who do not want it to be this way. But our federal, state, and local governments prioritizing funding for militarized policing and incarceration over fully funding social safety nets, that's what has led to a crisis in our local communities where harming us is not just accepted, but it's encouraged. In 2015, the Department of Justice found that St. Louis officials evaluated their performance on the amount of revenue they produced. So much so that in 2012, 13% of Ferguson's municipal budget was funded by fines and fees. And the city budgeted almost a quarter of its revenue from fines and fees in 2015. And let me just say, because we didn't know. So many of us in this community, we didn't know that this was a problem, that this is something that shouldn't have been happening. We were just used to it being the norm. That's a big part of the problem. Unsurprisingly, the DOJ also found that 93% of those arrested were Black, whereas only 67% of Ferguson's population is Black. Black drivers were also twice as likely as white drivers to be searched during traffic vehicle stops. The reality is that too many people live in endless cycles of punishment that are deeply linked to violent and traumatic encounters with police, the threat of going to jail, or having to spend money you don't have to pay exorbitant fees. Judge Foster, how does the imposition of fines and fees affect people's livelihoods, our country's economic growth, and public safety in our communities?
Thank you for the question. Let me start with your with public safety, because there has been some research done, and it's very important to emphasize we're all concerned about public safety and we're all concerned about crime. But what we know is that fines and fees can drive crime, and they have a dramatic impact on law enforcement's ability to fight crime. And let me just give you a couple of numbers. In a study that was done of cities that rely on fines and fees for some of their revenue, what the study authors found is that for every 1% increase in revenue that a city derived from fines and fees, a 1% increase in fine and fee revenue meant a 6.1% decrease in violent crime clearance rates, right? So we're not spending police resources on violent crime, we're spending police resources on raising revenue. Similarly, for every 1% increase in revenue that the city relies on from fines and fees, there was an 8.3% decrease in property crime clearance rates. So police are not solving property crimes, they're raising revenue from fines and fees. That's not good for anybody, and it's certainly not good for public safety. So that's an important point, and I think it's really critical that we understand that. As Professor Harris mentioned, we also know that people commit crimes to pay their fines and fees. I was a judge. It's rare that people admit to committing crimes. But in a study that was done of over 1,000 people who owed fines and fees, 38% admitted to committing a crime to pay their fines and fees. Now, that's just not helping our community's public safety.
It's not at all. But thank you, Judge Foster, for all of that information. I don't think a lot of people know that information that you just gave, those numbers. Fines and fees. What we do know, though, is that fines and fees seem to show up at every level of the system. That's what, a lot of people do know, that we look at fees for traffic and detention, phone calls from jail, commissary, fees for pretrial release. That's what we know. So thank you for that information. Now we need to do the work to make sure that we change this. Ms. Woog, from your testimony, I gather that there has been some substantial amount of reform on the state level. Can you just briefly tell us what policies or reforms the federal government should promote?
Yeah, absolutely. I mentioned some local reforms that we're seeing that I think are exciting. I think that there's experimentation happening on the local level that the federal government could play a role in supporting. So for example, text message reminders, redesign of court forms. Most people don't know that they have options besides paying a full amount, which they do under the law in Texas. They have options for waiver, reduction, community service. Our community service law allows people to do self-improvement work as part of community service. So taking college classes and that kind of thing. So we really think that encouraging people on the front end to help resolve their debt could help take care of a lot of the problems that we're seeing on the back end. I think the federal government has a role to play in supporting that kind of experimentation that's actually pretty low cost and can, once it gets started, can kind of keep up without needing these additional grant funding over and over, as people have mentioned.
Thank you, and I yield back.
Let me thank you for your questioning to Madam Vice Chair and your contributions to this committee. Now, it's my privilege to yield 5 minutes to the ranking member of this committee, Mr. Biggs.
Thank you, Madam Chair. Appreciate that. Mr. Head, Congress has gotten in the bad habit of using grants to force its preferred policies on states when the federal government does not have the constitutional authority to mandate that states act. This would be one of those areas. Do you support states addressing issues related to fines and fees?
I do support states' efforts, yes.
And are you aware of any federal law that prohibits states from making these changes?
No, sir, there's no federal prohibition against this.
Are you aware of states acting to make changes, whether it's regards to fines or fees or victim restitution, without federal coercion?
Well, yes, sir. We've enumerated several examples over the last particularly 5 years that the reforms on the state level are actually accelerating.
So, for instance, we had one witness just testify that 22 states have made changes with regard to suspension of driver's license for failure to pay fees and surcharges.
Correct, on the driver's license issues. Yes, sir.
Driver's license issues. So Arizona, Oregon did that.
Yes, sir.
Arkansas, limited situations in which court can suspend a person's license. California has acted in some ways. Colorado, Delaware, Idaho, Kentucky, Maine, Maryland, Michigan, Minnesota, Nevada, New Jersey, New Mexico, Oklahoma, and within Seattle, Washington's municipal courts have all engaged and taken action, as well as Texas, Maryland, New York, Utah, and Virginia on these types of issues.
Yes, sir, that's right. It's literally coast to coast at this point.
Yeah, and were any of them mandated to do so by the federal government?
Not to my knowledge, no, sir.
In fact, we talked to, I wasn't going to bring this up, but we talked about civil RICO statutes earlier today, and my home state, Arizona, now requires a conviction before proceeding on civil asset forfeiture, which is a huge, huge departure from the civil asset forfeiture realm today. So that's, to me, that's very interesting. Well, one thing that I have found somewhat troubling today, as a guy who practiced in this field for many years, tried hundreds of cases, and dealt with this issue, is the conflation of fines with fees and surcharges and victim restitution. So I want to briefly make sure we all understand what's being said and the delineation that goes on here. So Professor Foster, for instance, mentioned that in California, there might, if you have a $100 traffic ticket, it might get ratcheted up by, that's the fine, it might get ratcheted up with fees and surcharges by an additional, I think $390, is that what you said, Professor Foster? So, and in my home state, it's about, I want to say you could get whacked on an additional $120 or more, somewhere in that neighborhood. So you get a fine of $100, you get $120. Surcharge, which that's the vernacular we use, but it's the same thing as the fees and surcharges. It's going to a whole host of things. But we haven't talked about the victims of crimes, because there are some of the things we're talking about, there really is no apparent victim. You're dealing with actually a punitive fine, and you're dealing with some kind of not a restitution, but some kind of a fee or surcharge that's being disseminated, whether it's ostensibly to help police functions, police equipment, court defrayal of costs. In Arizona, there's even a very small portion that goes to the state general fund, for Pete's sakes. So, I mean, you have massive, this structure of fees and local jurisdictions are setting them up, the states are setting them up. But we haven't talked about victims' restitution and the impact that has. And I raise that because, to my way of thinking, part of what the justice system should be focused on is to make sure that an innocent victim of crime is made as whole as possible, and that could be a problem as well. So is there anything that you know of, Mr. Head, that deals with federal mandates with regard to how states administer victims' restitution programs?
To my knowledge, there aren't federal mandates on the restitution. I mean, there are certainly federal grants that are oriented. You know, it's, certainly VOCA and VAWA are overwhelmingly devoted in that direction. But those have grown significantly over the last decades. But it's been, frankly, a little bit mixed results as to whether it's actually, those funds are disseminated truly to victims, or if they're disseminated to peripheral services that may not truly be delivered to victims.
Yeah, so this, I do think that needs to be cleaned up and looked at as well. So I mentioned in my opening statement, Madam Chair, that I do think this is an issue that needs to be addressed. But one of the things that we're seeing is that many of the states are actually undertaking to address these issues without the interference of the federal government. I would like to see us let that go a while longer. I prefer to see state action. I'm a big believer in federalism, and I believe that we have very limited jurisdiction, and that's why we end up saying, well, let's do a grant program or find some way to incentivize. Whereas I think the states, with the help of some of the folks up there who are advocating, making advocacy within the states are responding, and that's where I'd like to see this go. And with that, Madam Chair, thank you for holding the hearing today and letting me take some time. I yield back.
The Ranking Member, thank you for your important contribution to this hearing, and thank you for your inquiry and your ask of consideration. Let me also thank the members of our committee, Mr. Nadler, Mr. Chair, Ms. Bass, Ms. Demings, McBath, Dean, Scanlon, Bush, Cicilline, Liu, Correa, Escobar, and Cohen, who've been very helpful in many of the aspects of our work, and to thank those who are present, Ms. Sparks, Mr. Gohmert, gentleman from Wisconsin, and Mr. Biggs and Mr. Stubbe. Thank you for your very constructive participation as well. Let me ask unanimous consent to place in the record a letter from the National Legal Aid and Defender Association, testimony against HB 3413, the Murr Emily Culp Advocacy Fellow, Texas Fair Defense Project, testimony in support of HB 2441 and HB 117, Emily Culp Advocacy Fellow, Texas Fair Defense Project, testimony in support of HB 162, Fernando Martinez, tip of the iceberg, how much criminal justice fees does the United States really have, fines and fees, justice, the price of justice, fines, fees, and the criminalization of poverty in the United States, University of Miami Race and Social Justice Law Review, Judge Foster, the steep cost of criminal justice fees and fines, the Brennan Center of Justice. Let me thank I ask unanimous consent, and they're so ordered to be in the record.
Madam Chair, I have one request for unanimous consent.
Then you are yielded to.
Thank you, Madam Chair. We have a letter from someone named Vikrant Reddy, and I'd ask that be admitted without objection.
Without objection, so ordered. Let me indicate that this hearing, a fine scheme, how court imposed fees and fines unjustly burden vulnerable communities, is a very important hearing. I do want to acknowledge, with a great deal of appreciation, the signing, Mr. Ranking Member, of the Victims of Crime Act fix, which really should speak to all of us who, as we are facing a surge of crime across America, we're all trying to determine and discern its cause, that we are taking care of our victims, including in that of victims of crime in the Federal Victims of Crime Act, and it also helps to bolster crime funds or victim crime funds in the states, gives a certain amount of requirements and an accounting. It also includes human trafficking, and what it does is it opens up the victim crime fund of the federal government to receive dollars from settlements, restitution, and other equitable fines. In the federal system, there is a limited number of juveniles, as we have said, even though the federal government carries a big stick, and they are basically not engaged in those kinds of fines and equitable relief and settlements. Those are mostly corporate crimes. But I think it is important for us in this hearing to announce that victims are our concern, and the conversations that we're having are separate and apart from what is being done with these fees and fines as it relates to victims. We do not choose here to undermine any efforts to be able to make victims whole. and that is evident by the federal law that I had the privilege of having signed into law. It was a bill that Mr. Nadler and myself and others carried and was supported with great support in the United States Senate. So that is what we want to leave behind. Victims are not to be deprived or suffer, but we must recognize cases like Ms. Soto and the sacrifice she's made for her children. And I do want to acknowledge that as I thank all of the witnesses. Judge Foster, thank you so much for a very important contribution. Ms. Soto, as a mom, and certainly as someone who's touched our heart, we wish your children the best understanding of your sacrifice, and we certainly thank your son for his sacrifice. And if we could, we would say love, love, love in your family, because you are certainly our hero for coming here and telling your story. We thank you so very, very much. Thank you, Mr. Head, for an important perspective. And thank you, Professor Harris, for your contributions as well, and Ms. Woog for highlighting Texas and what states do. We will now proceed, this concludes today's hearing. Thank you to all of our distinguished witnesses for attending and all of our members. This hearing is now adjourned.